I have the names of our participants, please.
Lee Heiss, lawyer guardian ad litem.
Nastasia Thomas, counsel for the department.
Brittany Stover, foster care worker with the department.
Michael McFarland, representing father, who is not in the hall. I do not believe he's on Zoom. The worker attempted to reach out to him. He's not returned the telephone call.
All right, Ms. Berger.
Thank you, Your Honor. Ariel Berger here on behalf of Mother Christina Orozco.
Okay. Thank you. Welcome. All right, Mr. McFarland, you indicated you may have a preliminary motion.
If my client has been served, Your Honor, without his presence, I cannot be effective counsel for his termination trial today. So I would ask to be excused from further participation in the hearing today.
Look at that issue. It looks like there's an acknowledgement that was filed in our court. I don't know if this has been circulated to all the parties, but it looks like Randall Order was sent an email. I'm not sure who emailed him, but this particular proof of service is not signed. But it would appear he did get it by email, and then he acknowledged service on 11/3/23 at 8 a.m. of summons and petition and a supplemental petition. Is that accurate, Ms. Thomas, if you know?
Yes, yeah, I just reviewed that with Ms. Stover, and the proof of service was not filled out entirely, but she did personally serve him, and he did acknowledge it, and that's the signature that we have on that second page.
Okay. Any other objections or issues on the issue of service?
No, Your Honor. With that, I would continue my renewed motion to be excused from further proceedings.
All right. Well, I guess the other question I would have, okay, so the summons would have had the date on it. All right, any objections to Mr. McFarland's motion?
No, Your Honor.
No.
No, Your Honor.
Thank you. Thank you.
Thank you.
You may be excused. As it relates to the order of events for today, this court typically consolidates the review with the matter of the request for termination as well as permanency. If you have any objections to that process or procedure, I'd like to hear them now, or any thoughts on it?
No, Your Honor. We're fully prepared for that.
Ms. Berger?
I have nothing to add, Your Honor.
All right. Very well then. Anything by way of openings today?
No, Your Honor.
Ms. Berger?
No, Judge, I would just reserve some time in closing and note that my client does want to testify today.
Absolutely. Anything by way of opening?
Your Honor, I would just report that I have visited with the children face to face in their relative placement. Their needs are being met, and they are in their counseling, and everything is up to date. So they're all in school and extracurricular activities. And it will be my recommendation that you consider it to be in their best interest to remain in that placement. And I will also summarize the best interest factors after testimony. Thank you.
All right, thank you. Your first witness then, Ms. Thomas.
Honor, if Ms. Stover can be sworn in.
Stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Proceed at will.
Thank you. Ms. Stover, for you provided a court report for today's hearing, correct?
Correct.
And this one, we don't have a cover sheet, so I just want to make sure that we just all have the same attachments, okay?
Okay.
So in addition to your court report, there is the case service plan for mom and for dad. And then there is, sorry, scrolling down there. An email sent from the relative caregiver with a very thorough reflection of everything that's happening with each child.
Would you mind moving that microphone a little closer to me? Thank you.
And then there are LDC screens for Ms. Orozco.
Correct.
And the forensic fluid screens, and I believe that's from the new referral.
Yes.
For Ms. Orozco. There's then a counseling letter for Ms. Orozco.
Yes.
For Ms. Freeman, is that correct?
Correct.
And then there is a letter from counselor for Mr. Orner, is that correct?
Correct.
And then also a letter from the youth AO's counselor,
Yes.
and then a letter for the 3 girls counselor, Ms. Moore.
Yes.
Has there been any other documents that have been circulated since you've provided this report?
No.
Okay. And are there any updates or modifications that need to be made to the report or to the attachments?
No.
Did you draft the supplemental petition for termination of parental rights as relates to both parents in this case?
Yes.
And that was filed on October 18th of 2023?
Yes.
And since then, has there been any change in circumstances that would make you suggest or recommend that we do not proceed on that petition today?
No.
Thank you. At this time and during this last review period, so covering about 2 months or so, how would you describe the parents' level of compliance with and benefit from their case service plans?
Non-compliant and limited benefit.
And so we're just going to kind of look at each parent individually. I think Mr. Orner might be the easier one to kind of get through at this point in time. Have you had any contact with him in the last 2 months or since the last review period?
So I was able to reach Mr. Orner by phone to schedule to meet with him, to go over his case service plan and to serve him documentation. He scheduled to meet with me at his home, which then he no-showed. I attempted to go to his girlfriend's house. He provided me an estimated address. He said he didn't know exactly what her address was. So I attempted to meet with him there, and nobody answered the door. I called him several times that day requesting him to return my call. He did not, so I met with his probation officer to arrange a meeting with him, and he immediately called her back, scheduled to see her the next morning, and so I was able to touch base with him and let him know about court today, and his non-compliance with his case service plan.
And did he provide any documentation to counter any of the reports that you've made?
No.
Okay. And when is the last time that he's seen his children to the best of your knowledge?
I would say it's been probably about 3 or 4 years now.
Okay. And since you've been the foster care worker, has he asked to see them at all?
No.
Has he provided any income or any materials or anything to support them at all?
No.
At this time, do any of the children, to the best of your knowledge, have any type of bond with him?
No.
Okay. And as relates to Mr. Roscoe, I believe during last review period, she was in a treatment center, so to speak, and it seems that that is still occurring in this review period. In what ways, I guess, has she not been compliant with her case service plan?
She hasn't, so she is in Dawn Farms treatment facility. I have attempted to reach Dawn Farms to get an update on services. I was also inquiring about where her location was because I wasn't able to secure a location for her. And I was informed that there was no release of information on file. When I met with Mr. Roscoe on the 22nd, she informed me that all of her services are through Dawn Farms. So right now I don't have an update on how services are going with Mr. Roscoe other than what I referred her for here in Lenawee County, which was with Miss Freeman through Catherine Cobb.
And Miss Freeman's emails to you and then her letter, were you able to review her emails to you and then the letter?
Yes.
And do they, I guess, are they congruent?
No. In her emails, Ms. Freeman reports that she's hardly met with her, that they haven't started on the workbook that Dr. Haugen recommended. But in her letters, she reports that she meets with her and she's making progress.
And do you have any proof of employment?
I do not. At my meeting on the 22nd with Ms. Orozco, I did ask her for a pay stub, but I have not received that yet.
And is there any indication that she could provide for all children's basic needs, housing, clothing, utilities, food?
No.
In her current housing situation, would that permit for the children to live with her?
Currently, the housing that she is in, she has roommates and it's not appropriate for children. Upon talking with Ms. Orozco on the 22nd, she indicated that there is another program that she could apply for that would be suitable for her and her children, but there's no known opening. She said she would have to apply for that. So as of right now, today, her kids could not return to her.
Okay. And you indicated, I believe in your report, that parenting classes have been completed?
No, she hasn't turned in any proof of parenting classes since spring of 2023. I did refer her to parenting classes in Washtenaw at her request, but I have no updates on how that's going. She was also referred to Dr. Haugen's workbook for abuse and neglect of children, and so the department purchased that for her to work therapeutically with Ms. Freeman, and Ms. Freeman indicated in her email to me that they had not started that workbook yet.
Does she indicate that Ms. Roscoe is living with an LTP, Mr. Hall, and they were living at his sister's mobile home? Do you know if that's like the backup plan after treatment? Do you know anything about that living arrangement?
I do know that he wanted, according to Ms. Orozco, he wanted to move in with her before she got into treatment. But she declined and moved in with a friend. As far as what Ms. Orozco reports to me is that she wants to remain in her treatment program for as long as possible. The treatment program is up to 2 years. As far as her goals after that, it's unknown.
To the best of your knowledge, why is she in treatment?
She reports that she has challenges with alcohol and cannabis use.
Okay. And in the psychological or any other reports, was there any indication of alcohol abuse?
No. Ms. Orozco reported on the 22nd that she started using alcohol use during her relationship with Mr. Orner, and then over this past summer, it intensified.
And you don't have any drug screens that are updated to, I mean, I guess, is there any updated drug screens for us? I know you have them in the court report, but what have they said?
That they're negative.
Okay. And there were a lot of no-shows, and that's partly due to location, correct?
Right.
Okay. And then also the forensic fluids lab, how would that work? I guess, like, would Ms. Roscoe have to go to the DHS there in Washington
No,
County?
she goes to the Washtenaw Urgent Care, and they have a person that tests there every day.
Okay. And based on the report, she's missed 2 of 4 of those?
Yes.
As it relates to the children, at this point in time, how would you describe their relationship or their bond with Mr. Roscoe?
Their bond with Mr. Roscoe has significantly deteriorated. The children continue to process the trauma they experienced in the care of their parents. And the children realize that placement with grandmother is the most safe and stable for them right now.
During this review period, based on the petition, there's indication that there was a complaint filed regarding, a CPS complaint filed regarding the children, and additional abuse that they may have endured by Mr. Hall. And can you just give us a little more information on that, or what happened with that case?
I believe what you're referring to is a complaint made by Mr. Hall's daughter regarding recollection of abuse she witnessed by Mr. Hall.
Okay. And was that something that you were aware of? I guess the abuse that the children had endured by Mr. Hall?
Yes.
Okay. To the best of your knowledge, does Mr. Roscoe provide financially or for the children in any way?
Not to my knowledge.
And the children, a couple of them are old enough to voice an opinion as to their permanency preference, I guess. What have they said, or what is their opinion about their future?
The children who are old enough to voice their opinion, they've all, AYO has been back and forth about his permanency goal, and this recording period, he's made it clear that he wants to move forward with adoption by his current placement. He feels that he wants finality, he wants permanency, and he's ready to move on from this. He's processing all that he's been through with Mr. Schoonmaker, and he feels very confident and comfortable in continuing on this path. The girls have always, from the moment the allegations were talked about during the children's advocacy appointment, that they want to remain with their grandmother and they want adoption. The girls have reported that they don't want a relationship with their parents.
And when they are in a relative placement.
They are.
And other permanency goals were explored, correct?
They were.
And for these children, finality seemed to be the most important for them. Is that accurate?
It is accurate, yes.
And typically that relative placement does weigh against termination. But in this case, were either the parents able to benefit from that relative placement, meaning they were able to engage in more contact with the kids, able to maintain that bond, celebrate holidays together, be there for birthdays, things of that nature?
No, due to the allegations regarding the trauma the children experienced with Mr. Roscoe and Mr. Hall, it really caused separation with Mr. Roscoe and her family. And so she does not have a close bond with her family at this time. And so she wasn't able to benefit from that.
And the grandparents are willing to provide permanency through adoption, correct?
Yes.
And they have continued to work with licensing it for that purpose, is that correct?
Yes. They are connected with Fostering Solutions right now, and they're being signed up for classes.
And overall, since they've been in care of their grandparents removed from their parents' care and custody, how is their general well-being?
They're doing really well. As far as like AO, she has, when we first got into this case, AO kept her head down, was very shy to talk to anybody, lacked self-esteem. And to see AO grow in such a positive way is really wonderful. She's now participating in extracurricular activities. She's working and processing her trauma. She can tell me on one hand how many coping skills she has and how she utilizes them in certain situations. She's really benefited from the services that Ms. Moore provides. The other children are also AYO. He's doing really well in school. He's making friends. He's learning how to have healthy relationships with his peers as well as with girlfriends through therapy with John. At our last visit on the 22nd, he reported to me that he's zen. He's like in a good spirits. He's in a positive mood. He has a good mindset and he doesn't want to reverse that. He feels like he's gotten to a very good place.
Is there anything else that you want to highlight from your court report or from your own knowledge or from the past proceedings to help the court make a decision as to whether the termination of parental rights today is in the children's best interest?
It is the department's concern that Ms. Orozco's relationship with Mr. Hall is still active, and Ms. Orozco continues to deny the allegations made by the children of the trauma and abuse they endured while in the care of Ms. Orozco and Mr. Hall. So I just want to bring that to light, that is still a concern.
Thank you. Your Honor, I have no further questions. Okay.
And the last thing that you said about what remains a concern?
Ms. Orozco's relationship with Mr. Hall, and that she still denies the abuse that occurred under her care with Mr. Hall.
Thank you. Sorry. No, and at this time, I would also move to admit the court report with the attachments. Thank you.
Objections?
No objection.
No objection.
Kind of phone number, enter the waiting room. I'm gonna let that person in and try to find out who's next. Good morning, this is Judge Sala. I've just allowed you into the room. Who's joining us from the phone number ending in 3655? Your name, please?
This is Richard Stump, the kids' uncle.
Okay, all right, thank you, welcome.
Thank you.
Okay, questions, cross-examination for this witness, Ms. Berger?
Yes, thank you, Your Honor. Ms. Stover, you testified that you haven't been able to get updates from Dawn Farms. Is that correct?
That's correct.
Have you been able to get any updates from my client at all?
I did get updates from her during our visit.
Okay, and what updates did she give you regarding her counseling and group?
She informed me that she attends all services through Dawn Farms, and that she attends counseling through Dawn Farms once a week, in group once a week, and that she tests for Dawn Farms every Sunday.
And have you been?
No, I'm sorry. She goes to AA every day and sees her house manager on Sundays.
Got it. Okay. And have you gotten any copies of those test results?
I have not from Dawn Farms, just from when she tests for me through forensic fluids.
Okay. And again, those have been all negative, right?
Right.
And is this the first review period where she has exhibited all negative substance abuse screens?
No.
Okay. So she has.
When she would screen in the past, she did have negative screens.
Okay. When's the last time she had a
But
positive?
her testing was inconsistent.
Okay. When's the last time she had a positive or missed screen?
I believe her last missed screen was on 11/17. I don't have the date in front of me. I'm sorry.
So approximately 2 weeks ago.
Yes.
And do you know if she has a plan for housing once she's not living with the roommates right now?
I do not know her plan. I know that, as I mentioned earlier, there's a program that could help her and her children if they were to return to her care. But as far as that, I'm not sure. I know she wants to stay there the max that she can.
Okay. And you mentioned that that you still have a concern with Mr. Hall and the abuse that the children suffered at his hand. Is that correct?
Yes.
And do you know the status of any criminal investigations related to that?
I do know that it was over the summer, it was denied by the prosecutor's office in Ohio.
Okay. Do you have any reason to believe she's not completing services with Dawn Farms?
I believe she's completing services with Dawn Farms. They do have requirements that they do have to participate in services in order to stay in the treatment facility.
Okay. I have no further questions. Thank you.
Ms. Heiss.
How do you know that she's enrolled in Dawn Farms?
I went to her treatment facility and viewed her home. That's the only proof that I have.
So she was in aftercare when you saw her, correct?
Yes.
And how did you know it was a Dawn Farm housing?
Signs.
Okay. And then did you talk to the house manager?
I did not. I guess the house manager lives in a separate location. And comes and Christina sees her on Sundays.
So are you assuming that she did some treatment and now she's in aftercare?
So during the last court hearing, Ms. Orozco reported she was in Spira treatment facility, and I believe there was a worker there verifying that. I attempted several times to reach Spira after that court hearing to get in contact with Ms. Orozco because she didn't have a phone number and I didn't have an updated address for her, and they told me there was no release on file.
So we really don't have anything from an official that says she's enrolled in Dawn Farms.
Right. Actually, Ms. Berger did send me proof of enrollment, I believe sometime in October, where Dawn Farms sent her verification that she was enrolled, but I didn't receive any verification.
Enrolled in what?
The Dawn Farms Spira program.
Is that inpatient or outpatient?
Inpatient.
And was she successfully discharged?
I believe so.
What makes you believe so?
Based on Ms. Orozco's words, that she's in a step-down program.
How are you measuring whether she's benefiting from the groups that she attends, the counseling she's attending, anything that she's attending? How are you gauging her benefit from services if you don't have the service providers letting us know?
I'm not able to gauge any benefit.
Do you have AA signing sheets for her?
I do not. No.
So you said that she tested clean on the last test that you gave her, correct?
Yes.
You did not test for alcohol.
The screens for forensic fluid does test for alcohol. It does screen.
Where is the result for that?
It should be on the, should be on there.
On the summary piece?
No, on the actual screen. Yeah.
I don't see alcohol. And that's her drug of choice, what she's in treatment for, right?
Right.
A routine child welfare hearing exploded into a jaw-dropping courtroom battle as devastating abuse allegations, addiction, and years of family trauma were exposed. In an emotional showdown, the judge faced a heartbreaking decision that could permanently strip a mother of her parental rights, while the children made one shocking request: they wanted adoption, not reunification. As painful truths unraveled, the courtroom delivered a powerful reminder that protecting innocent children will always come before protecting broken promises.
Forensic fluids are tests that you gave her?
Their tests through, that we contract through Forensic Fluids, and they test her at Washtenaw Urgent Care.
So how do you know what the result is of this on this summary page?
So I have a login information on Forensic Fluid, and that's how I complete my referral. And so I can go on and look at any drug screens that she's missed or completed.
So this here doesn't tell me results. Do you agree?
No, that just shows missed appointments.
So how do I know what she tested positive for on positive, negative, 11/9, 11/17, 11/18, and 11/20?
I believe one of those, in my court report, they didn't have the results of that yet.
And then she missed 2 of those.
Yes,
Okay, so she's missed a screen on 11/9 and 11/18, correct?
yes.
And then the results of the 11/17 and 11/20, you've got results from 11/17 here, but I contend there's no alcohol test. You could probably see something that I can't see, but I don't see alcohol being tested for. And there's no other alcohol test that you've conducted, correct? No breathalyzer?
No.
And no screens from Dawn Farm, Spera? No
No.
science?
No.
No proof of employment?
No.
In this review period, Mr. Hall's daughter has made statements substantiating the abuse that brought the children into care. Is that correct?
Correct.
When you hear the statement that that child made, does it corroborate what these children have reported?
It does.
You said that you think mom may still be in a relationship with Mr. Hall. Is that correct?
Yes.
They're both in treatment in Ann Arbor, right?
Right.
Or what is the status of his treatment? Is he in aftercare?
I don't know.
Does he live in the same house as she lives?
I have no idea.
So they could be cohabitating, we don't know.
They don't know.
Thank you, I have nothing further.
Any redirect?
No, Your Honor.
Any recross?
No, Your Honor, thank you.
Thank you for your testimony. You may return to your seat. Any other witnesses?
No, Your Honor.
Witnesses today? I know you said your client wanted to testify, Ms. Berger.
Yes, Your Honor.
All right, come on up to our witness stand. Mr. Roscoe.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? This is careful.
Can you give us your full name for the record, please?
Christina Maria Orozco.
Thank you. Ms. Berger.
Christina, can you hear me okay?
Yes, I can.
Did you hear the testimony of the case worker today?
Yes, I did.
What would you like to add?
My housing is just women only. That not able to have relationships in the first year of the program, because the belief is if one relapses, the other one will relapse. And I do have my therapist numbers and her email, and there was a release signed for Spera.
When was that
The
release?
director, Ross, actually had me sign it.
When was that release signed?
10/28, because I just moved into the transitional program and he had me come back up to the detox center so that I could sign that release.
Okay. Back to housing. What is your plan once you transition this level of treatment?
There is a program, they call it Spare Roots program, where it would provide therapy. It would learn how to reassimilate me with the children. It would give programs for the extended family as well, so that it could be, all those relationships could be repaired if that was what was wanted. I do have my meeting sheets. I have every drug screen. The one that I did miss, that I know I missed, I called, I do have a statement from the nurse.
Let's back up.
Okay, I'm sorry.
That's okay. So this Spare Roots program, at what
Yes.
point would you be able to enter that?
If there was a possibility, I could, I've been talking to the counselors now about it, because I do, talk about anything that's like triggering in my life or anything like it could help me, with my relationship with the children. And all I have to do is when there's an opening that I could, if that's what I wanted, they would help me get into that program. Which it would still have the same accountability. I'd meet with the house manager, the children would have therapy, I would still have therapy. We'd do a family therapy, we'd go to, my drug screens would still be the same.
Okay. And is there a date or a timeline to where you could be in different housing that would be appropriate for the children?
As of right now, the changing, it's always changing. It could be a 30-day wait, it could be a 6-month wait. But it's just me keeping up with like calling and telling them that this is a program that I'm interested in when there's an opening. I mean, I am saving money from my work.
Okay. And do you know what the wait list is right now to get out of your current housing? How long that wait list is?
To get out of my apartment transitional?
Yes.
As of right now, it's a 3-month wait.
Okay. And do you think that it's possible that you would be able to be in a position to have the children in your care in those 3 months?
I would love to, yes.
Is that realistic?
If I keep with my current program, then yes.
Okay. And you talked a little bit about what types of counseling you're receiving. Can you
Yes.
Can you expand on that, please?
Yes, I go to outpatient, what they call outpatient therapy, and we talk about it's in a small group setting where I'm matched with other people that have similar trauma and similar like drugs of choice, and we talk about our trauma, our coping skills. We do DBT, which I know I'm going to annihilate the name, dialectical behavioral tactics. And it teaches us like just different areas where like how to deal with things healthy and properly instead of just choking them down and just forgetting that they happened.
What types of things have you learned in that program?
I learned that my fight or flight was always messed up from dealing with a children's father for so long. I just thought everything was always a fight, and there was things that I could have just been the bigger person about and just walked away.
And have you learned about taking any accountability?
Yes, this program is very much about accountability. Like we account for everything, like especially in my apartment, if somebody leaves something out, you know, we're like, hey, you know, what happened? And in my program, it's very much like women reach out to women. Men are supposed to stick to the men, just because there are those like lines that could be crossed. And in early sobriety, you don't need that extra stress and you don't need that extra distraction to your recovery.
Okay. And you heard Ms. Stover say that she has concerns that you haven't taken any accountability towards the abuse that your children suffered at the hand of Mr. Hall, correct?
I'm sorry, what was that?
You heard Ms. Stover say that she has concerns.
Yes, I heard her.
Mm-hmm. Okay. What would your response be to that?
there are ways that I could have been a better mother. I am diagnosed finally with bipolar. So a lot of my actions stemmed from my good days and my bad days.
Okay. And are you attending AA?
Yes, I am.
And tell us more about that.
I go to a meeting every day. On my days off, I go to 2. It helps with learning how to ask for help again. Because when I was depressed and hurting, I just gave up on life and I didn't ask for help. I just wallowed in self-despair and I turned to drinking. But now it's learning how to cope with all the things that were triggering, all the things that I didn't deal with in my marriage to Mr. Orner. Is learning about dealing with ways that I could have been a better mother. I could have been more attentive, but because of things that I was raised with, things that I've seen in life, that I just felt certain things were normal.
Okay. And you attend individual counseling?
Yes, I do. I still meet with Ms. Freeman.
And what are you working on with Ms. Freeman?
We are going over more in-depth. She knew a little bit about the trauma that I had faced with Mr. Orner, but we're going into more detail because I am in a more mind-capable spot of dealing with that, to where I don't want to go drink or I don't want to go smoke weed or anything. And it's just more healthy for us to have that communication.
How often do you counsel with her?
Right now it's every Friday over Zoom.
Okay. And are there specific goals that you're working on with her that are related to the concerns in this case? So that are related to abuse, neglect, or dependency?
We're learning that I was very independent, but it was a very codependency independent. I had so much trauma that I didn't like asking for help because I had to prove that I was capable of doing things on my own. So when they crashed, I had no support system. And that's what this recovery community has done for me, is give me a support system that when I am having a bad mental day, I have somebody to turn to and be like, hey, this is not going well for me. Can you talk to me?
Okay. And talk to us about employment. Where are you at with your employment?
I still work for Speedway. I just moved up to the one in Ann Arbor.
And how far is that from where you're living?
A 10-minute scooter ride.
Okay. What do you mean by scooter?
I have an electric scooter.
Okay. And how much are you making currently there?
My checks average about $450 a week.
Okay. And have you tried to come up with any budget or anything that would help you use what you're earning to determine if you're earning enough to care for the children?
Yes, right now I set back $100 for my rent each week. I set back $100 for whatever needs or necessities I may need, shampoo, laundry detergent, and then the rest I really try to save.
Okay. And is that employment transferable if you relocate?
Yes, if I choose to go through Speedway, yes.
Okay. And talk to me about your sobriety. How long have you been sober?
Tomorrow I have 60 days.
Okay. Is that the longest you've been sober since the case is opened?
Yes.
And what is helping you stay sober?
being in the recovery community, being able to have a safe place to talk to people about my life, to talk to people about the hardships, the good, the bad, the ugly, and knowing that I'm not alone.
And have you been doing screens at Dawn Farms as well?
Yes, I screen for my house manager every Sunday. And then if you have like a squabble, like with a housemate, then she'll screen you both as an accountability. And then I go through the forensic fluids. And then for my outpatient, when she calls your number, then you go and drug screen for her as well.
Talk to us a little bit about the differences you've seen in yourself since being sober for 2 months.
I'm finding joy in the small things again. I'm writing my kids. I'm sharing pictures of them when I was so in my addiction that I couldn't, because I knew that I was horrible, or I thought that I was so wrong. And just talking about them and talking about the good, the bad, you know, the times with Mr. Owner, it's just helping have that perspective and have that safe place for me.
Okay. Have you been able to look inward on any of these
Yes,
problems that you've
and
experienced?
some of the chaos was brought on by me and my undiagnosed bipolar. And that is something I have talked about with Ms. Freeman.
When were you diagnosed?
When I was in Sparrow program, it was in October.
Of this year?
Yes.
And had you had that diagnosis ever previously?
No.
Okay. And since getting that diagnosis, are you able to take any medication or learn any specific coping skills?
Yes, I'm on medication. It's a mood stabilizer, which helps me sleep more. It helps me get better sleep. It helps me, like my trigger for getting angry isn't, I wouldn't say it's gone, but it's more harder for me to get angry. It's like gives me that pause to be able to stop and think, like, is this really worth me getting angry about, or is this something that's just going to pass?
And what about transportation? What's your status related to transportation?
To who? What?
Transportation.
Oh, I'm working on getting a car.
Okay. And do you have money saved?
But I do have some money saved, yes. But
Okay.
for the first few months of transitional, they prefer you not to have a vehicle for the purpose of when people are in their addictions, they isolate, they don't ask for help. And part of not having a vehicle is you learn to ask people for rides to meetings, to like the grocery store, so you can relearn how to put yourself into society and to ask for help.
And how are you getting around right now?
The bus system and or my scooter.
Okay. Is it like a scooter that you own, or is it like a ride share thing in your community?
No, it's in the house.
Got it. Okay. So when you leave, that won't come with you.
No.
Got it. Okay. Is there anything else that you want to add today?
No, I do have, like I told you earlier, I do have proofs of all my meetings. I have my drug screen receipts. I have the paperwork that they gave me, a letter of presence.
And have you
from
have you sent that stuff to the caseworker?
Yep.
Okay. And what are you asking the court for today?
More time.
More time to do what?
To let this program really work. I'm seeing impeccable growth in just a short time that I've been there already. And I believe with more time that I can be the stable, not chaotic mother that my children need.
I have no further questions, but some of the other attorneys may, okay?
Okay, thank you.
Cross-examination, Ms. Thomas?
Your Honor, as a point of order, may I? I'm wondering time-wise, if you'll allow us to work into the lunch hour. I'm very willing and want to do that, but it kind of makes a difference. I don't know if you can get your ending done, your comments done, or if you're gonna reschedule us for that, or where we should break.
It's a fair question. I think if we use the lunch hour, there's a possibility. I'm not sure if you have any other witnesses, Ms. Berger.
I do not.
Will you have anyone you'd like us to hear from?
No witnesses.
All right. Would you like to use the lunch hour, Ms. Thomas?
I'm agreeable to that.
Because I can look for some time, but if we reschedule, it looks like it's going to be. I mean, I can back it up against another review, permanency planning, termination trial that we have scheduled for Monday. I'm not sure how much time that one will take. I could put it in the afternoon.
The caseworker's out next week. I know she can get coverage probably, but.
I don't want to go out too far. I can also give you a backup against a jury trial scheduled for Monday, December 11th. In case that doesn't go. Otherwise, we can try to get done in the next hour.
Yes.
Right, we'll just try to get done in the next hour as far, I mean, if that's okay with you, Ariel.
Judge, I am working at my home right now and I have to be at court at 1 and then I have to be with you at a facility by 2:30. So I would say if we can get done in the next half hour, I'm game, but if not, I would ask that we adjourn.
All right. Why don't we go through the next half an hour and see how much we can get finished? Okay.
Thank you.
Okay. Ms. Thomas, did you have any questions for Ms. Roscoe?
No, Your Honor.
Ms. Heiss?
No questions, thank you.
Okay, thank you for your testimony. You may return to your seat. Confirmation one more time. As far as any other witnesses, Ms. Berger?
I have none, Your Honor.
Ms. Heiss?
I have no witnesses, but I do have a recommendation regarding best interest before that I'd like to make too. I can make that in my closing or as a separate report.
I think in your closing would be great.
Thank you.
I prefer you were able to hear any of the comments made by the other attorneys, and then you would be able to take that into consideration as well.
Thank you.
Comments in closing, Ms. Thomas?
Thank you, Your Honor. I think I'll start with Mr. Orner, as I think that one's probably a little more straightforward. Although not alleged or pled into the supplemental petition, I believe that the statutory grounds of MCL 712A.19B3A2 or II would have been met in this case as well. I think that Mr. Orner's lack of engagement in our court proceedings throughout the pendency of this case is the clear and convincing evidence that he has effectively abandoned the children. He has not had any significant contact with them in years. The children have been in care for about 1 year and 4 months now, and he has not done anything to support them. He did enter a plea, he did enter a case service plan, and that leads me to the CI or C1, that it has been more than 6 months since he's been a respondent parent and ordered into his dispositional order and case service plan. He has not complied with that, nor shown any benefit from that, which also lends itself to the conclusion that the children would be harmed if they were to be returned to his care. And the conditions that led to the adjudication continue to exist. And then also that last part, what is a reasonable time to wait for him to come around? I think that he's demonstrated that at this time, there is no reasonable likelihood that he would do that in a reasonable amount of time for them. As it relates to subsection G, he has also failed to provide any financial support to them, despite indicating that he does work. He has not provided any of that proper care and custody that we would typically look for a parent to support their children. And again, that reasonable time, considering the children's ages, this has been an ongoing pattern for years, and that has been highlighted at least in the last year as relates to him. And I believe all those things combined lend themselves to subsection J, that there's reasonable likelihood based on the conduct and capacity of Mr. Orner, the children would be harmed if they were returned to him. They don't have a relationship with him. He seems to be compliant with his criminal proceedings stuff with probation, but doesn't, communicate with Ms. Stover. He hasn't asked about the children. And frankly, they don't have a relationship with him, which I think then lends itself to the best interest factors as it relates to Mr. Orner. But before I move on to that, as relates to statutory grounds for Mr. Roscoe, she too has been a respondent parent in this case for more than the 6 months that is required by the statutory ground that is pled here. And the conditions that led to the adjudication continue to exist. And at that time, there was significant concern about the children's welfare and care, so treating the children with THC, their instability in housing and where they were. And so overall, all of those really basic parenting skills that we were looking for that led to the harm of the children, that is where we were at adjudication. And as it is today, the children throughout this process have reported more and quite severe abuse and what I would say amounts to torture while they were in the care of Mr. Roscoe. At the hands, whether that was her or Mr. Hall, her lived together partner. Today, the accountability component, and I put that in air quotes there, was that she was diagnosed late with bipolar. Again, I think that reflects back in her psychological, where there's a slow self-disclosure tendency or a tendency to minimize her own actions and the needs of the children. The children have worked really hard in their own therapy during this case to overcome that. And that really hasn't been addressed or even testified to by Mr. Roscoe. And so for those reasons, I believe that there is clear and convincing evidence that the conditions continue to exist that led to the adjudication and that they wouldn't be rectified within a reasonable amount of time. We have 2 months of sobriety and the children have been in care for 16 months now. So I think that speaks for itself. Ms. Roscoe also has maintained employment. We don't have updated pay stubs of any of that or any updated budgets. And although she says there's, these releases have been signed, she too is capable of providing this information to Ms. Stover and has failed to do so. At our last review hearing in October, Ms. Heiss specifically asked her why she hadn't complied and why she had missed drug screens, and that she was supposed to be giving her pay stubs to Ms. Stover and reminded her to look at her case service plan. And Mom's response was she had forgotten. And she had forgotten the steps to reunification with her children. So I think that for those reasons, that also speaks to the statutory grounds that are pled in our petition. These children have waited a significant amount of time. And I know that we sometimes have children in care longer, but these children have had severe trauma in their life and they are seeking and begging for finality in this case. There is no indication that Ms. Roscoe would be able to provide for them in the way that they need to, given their past trauma. They haven't had communication with her in several months. They haven't even started this family therapy component that would need to be broached in the event that termination does not happen today. And so based on that, we are asking the court to find that clear and convincing evidence does exist for at least one of the statutory grounds that are pled in the petition. As relates to the children's best interests, I know that Ms. Heiss does a very good and thorough job on that argument, and I will defer to her in that regard. But I do want to highlight that the children's relative placement has really provided for all of their needs in this case. And I believe that, I don't think it's undisputed that that was in part happening before this case was open. These children are bonded, all of the children are bonded with the maternal grandmother and step-grandfather, and they have expressed in their own ways their desire for that finality and for that permanency through adoption. The bond with the parents has been one with Mr. Orner is completely non-existent, given his abandonment of them. And with Mr. Roscoe, I would also say is very diminished and also questionable, given the harm that they suffered in her care. Neither parent has shown an ability to parent them appropriately. And that is also reflective in their lack of compliance with the case service plan, or how long it took to become in compliance with elements of the case service plan. The current relative placement home provides for their needs. They have a really extended family network that really supports them, and they have these close relationships, and they're doing well in care.
A heartbreaking child welfare hearing took a shocking turn as years of abuse, addiction, and family trauma were exposed in court. Despite a mother's emotional plea for more time, devastating testimony from caseworkers and the children's own statements painted a very different picture. As prosecutors pushed to terminate both parents' rights, the judge faced a life-changing decision that could permanently reshape these children's future, proving that when a child's safety is on the line, second chances aren't always enough.
Meaning that, there any ethnic or cultural considerations are also being observed and respected in that home. And I think that a preponderance of the evidence from the record as a whole indicates that it is in the children's best interest to terminate their parents' parental rights in order for them to have safety and finality through adoption with their grandparents. Thank you.
Ms. Berger.
Yes, thank you, Your Honor. As my client testified today, she does believe that it would be possible for her to make enough progress in one more reporting period. As we all know, Judge, sobriety is not linear, and it's been a steady decline for Ms. Orozco until this last reporting period, where she was able to get some proper diagnosis, where she is in a stable living community, where she is able to get the treatment that she needs, not only to stay sober, but to become a better parent to her children. She is engaged in a lot of counseling, although it has not been 100% verified by the caseworker. Some of that has been verified by the worker. I'm not sure why we're having issues with the release of information still, but I do believe that that is on file. Housing right now, Judge, is one of the biggest barriers. And hopefully Ms. Orozco can get into some transitional housing that would be appropriate for her children in another review period. She's been employed. She continues to stay employed. This is her longest period of sobriety, I believe, during this case. And although she doesn't have a vehicle, she has been able to continue with her transportation, making it to appointments, making it to work, making it down here to court today. So at this time, Judge, although we are far into this case, we are not far into her treatment. And we're asking that she have more time to complete that treatment and hopefully be able to reunify with her children. Thank you.
Ms. Heist.
Thank you, Your Honor. With respect to the best interest of the children, I would ask you to consider the letter that is in the court report. Two letters are very helpful. My comments, the theme is, what about me? The kids would say if they're here. Mom's testimony twice now has been all me, me, me. My notes say me, 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 me. I didn't hear from her how the older of the LOs did in their 5K charity run. I didn't hear how the mother is addressing the trauma assessment requirements for that child, or the oldest, AYO. He has a lot of recommendations. This mom has all these things at the tip of her hands, and we didn't hear anything that she contributed from her savings or from her employment for any of these sports equipment, sports fees. These kids are very active in lots and lots of things, and I think there was a real absence of the kid's best interest in her testimony. I'd ask you to consider that again, if there's been a diagnosis of bipolar, we don't have that. And the caseworker is full-time, ready to receive this stuff, and I would say it's not the first time the court's been lied to. I have zero evidence. Where's the piece of paper? If this is important today and we don't want rights terminated, where is the piece of paper showing me that she is in AA? Apparently there's papers that, what does it require? A text, picture, counseling appointments, negative screens. Where are they? We've argued about this for 16 months now. Where is this? This mom hasn't had any visits since November 1st of 2022. Is she asking about the kids' wellness? Is she asking about their needs? Is she prepared to address their schedule? In addition to her own schedule with counseling and AA and house manager and work and those kinds of things, does she have any concept? How long will it take her to get the schedule for church and camps? And one of the kids has a mentor through school and sports and the school activities and the days that they are at school and the days they aren't at school. And what do they need for the 5K charity run? And what the ballet class, are the outfits up to date? Do they fit? When is the recital? All of these things are not something that mom is prepared on. I would ask you to consider that Mr. Hall's daughter is continuing to report the really significant abuse that happened in the beginning of the case. The children did not indicate to me that they've gotten any letters from mother. And I'd be really curious to see whether she has taken accountability for the stuff that's now been corroborated again, including waterboarding. One kid hitting the other kid with a whip, being made to do that. People being bound, people being tortured is a good word. I don't know whether, I don't hear any accountability for that, but I hear that we have, mom's working on getting a car. You know who else is? AYO. I would really, if those kids could be here, they'd say, this is supposed to be about me. My mom's testimony, really good that she's getting a car. What about, it's AYO's time to progress into being an independent adult. It's his time to benefit from the emerging stages that he's going through. And now mom is needing to do that for herself. How can it be that the littlest LO has no positive memories of her mother, and her mom isn't working on that yet? She's not working on any of the trauma assessment goals for that child. So I would ask you to consider, there's a lot regarding the best interests of the children in these letters from the placement, including the fact that there's guidance for the oldest child. The grandmother reports speaking to her and telling her about what he does like and doesn't like about girlfriends and counseling, and he wishes to be adopted. He has lots of activities. He's very serious about his counseling commitment. His success coach, his Omega, his church, he's getting good grades. An 84 in one class is good. We always have to watch to see how many classes is he doing, but you can see in these notes that Grandma's really on top of it, and that he believes that his parents don't care about him. I think he might be right. Judging by today, he might be right. So the next one in line is AO, and she is doing all kinds of things that promotes normalcy. She's in volleyball. She is doing less of the parenting, although it jumps up in her mouth a lot, and she wants to, because she's right. The things that she says is right, and but it's not her role. So she is addressing her mental health needs. It's really great to see that she's, I saw her in a really tender moment with the next in line, LO. They were doing volleyball back and forth on a trampoline. And I thought it was a gentle moment for the sisters to be together. And I really wish I could have heard the conversation, but I couldn't think of a way to sneak behind trees and hear them. But AO is becoming such a person who will ask for help. She is talking to her grandmother and getting guidance. It is her wishes that she is adopted by her grandparents. The LO is, doesn't love counseling yet, but she did some things that were outside her comfort zone. She is allowing her grandparents to sit down and talk through plans that'll make her happier. She does attend church in her youth group. She also wishes to be adopted. The littlest one is so full of life and joy, and she thinks her mom's a mean mom. And she doesn't have positive memories of her mother. I really wish somebody cared to fix that for her. She is in ballet. She's getting all these opportunities through her placement to go to the zoo and to a professional ballet and all kinds of assets that in this family placement have given these children lots of strength. So I would ask you to consider that. It's my recommendation that it's in the children's best interest that this foster home, which is a relative home, has advantages over the parent's home. The mother is not prepared to take the children. Father, let's take his action. Let's say actions speak louder than words. But you know, he didn't do either. He didn't do actions or words. And I think that that's indicative. I think that's who he is to the kids too. You know, what we're experiencing is what they experience. So, you know, we have 4 kids, 3 meals a day, which is a joke because they eat a lot. And so that's 12 meals times 7 days a week is 84 meals a week. They've been there about 64 weeks. And mom wants to talk about herself and whether she's ready for the children to come home. It's 16 months. The kids want finals. They want these lovely service workers to fade away. And the grandmother has demonstrated that she's making good decision making so that they can they have good support when we turn around. So I would ask you to consider that the termination of parental rights is in the children's best interest for the statutory basis that the state has articulated. Thank you.
Well, the court finds that all interested parties are given notice for purposes of today's review hearing, permanency planning hearing, and hearing on the termination of parental rights petition that was filed against both parents. Both parents were timely served, had the opportunity to appear and speak if they so chose. We did hear from Ms. Orozco, of course, and I'm glad to hear about that progress. But the court has an obligation to look at also the best interests of the children and weigh that progress against the permanency and stability needs of the children. And today, specifically, we have to look at where they are compared to where they could be if the case continued to move forward, and specifically as it relates to the comparison of homes between the two, as Ms. Heiss sometimes articulates. As it relates to reasonable efforts towards the goal of adoption, I do find the department is certainly making timely efforts. I do appreciate the update, especially around the licensing issue. I had asked specifically for that, and it was noted very detailed in the report, as well as many other issues that the court has to look at today very thoroughly. So thank you for your work on that. I know it took you some time, and I appreciate it.
No problem. Anytime.
Okay. I also find Ms. Heiss to be in satisfaction of her obligations, as always. Thank you.
Thank you, Your Honor.
And thank you to our attorneys and counselors for putting your time and efforts also into today's proceedings. All right. The children are not able to be returned to either parent at this time for purposes of the review hearing. Findings. Ms. Orozco is in a recovery program that does not allow her children to be able to be with her. She could potentially change that, but at this time, they're not able to join her. She is very new into the infancy of her sobriety, only 60 days, and the court would need a significant period of sobriety to evaluate whether or not there had been progress made on that issue. The issue of substances in this case is not really the first and foremost issue that brought these children into care. But it is an interesting one since it, by some reports, seems to be something that Ms. Orozco is struggling with and is clearly in recovery for. She had denied that as an issue during the psychological evaluation. But again, that goes back to something that Ms. Thomas mentioned about the low or slow self-disclosure tendencies that was noted by Dr. Haugen in his evaluation. Also, clearly, the mental health issues that she now talks about contributed to that, but we're not really outstanding issues when we open this case. The outstanding issues when we opened this case was the physical abuse of the children. Taking that issue into the findings that the court has to look at today is well framed. When I look at termination of parental rights, I have to look at whether or not there's clear and convincing evidence. And then, of course, the second part is whether or not there's a preponderance of the evidence as it relates to the best interest factors. The termination of parental rights of both parents, in this case, serves the best interest of the children. The statutory provisions I'm being asked to consider include, of course, section MCL 712A, point 19B3 for Mr. Warner, 3A, subsection 2, and J. So A, also though, CI applies to him. He did have both parents, in fact, were subject to an order of disposition, first on August 17th, 2022, and September 7th, 2022. Father entering into his plan in the September month of 2022. That was, I think, about the last time we saw him. He disappeared shortly after that, fell off the radar, if you will, and we didn't see any progress made around the very serious allegations of physical abuse at his hands. During the course of the case, we saw each children subject to the trauma assessment process, as was discussed at length today. They've all been diagnosed with complex trauma, some with additional issues and challenges as a result of the time that they spent in the home of both parents. He had some potentially some criminal issues pending, both parents did, but none of that appeared to come to fruition, with the exception that clearly Mr. Orner was on probation, has done well on probation, but the only services we really saw him undertake were those that were ordered as part of his probation. So I'm glad to see that he completed those, but as it relates to his children, he has had little or zero contact with them since the outset of the case, which clearly makes the court's findings as to whether or not he's abandoned his children very clear. In other words, we do have clear and convincing evidence that Mr. Randall Orner has abandoned his children under subsection 3A II, whether or not the child's parent has deserted the child for 91 or more days and has not sought custody of the child during that period. Under subsection CI, both parents in this case were respondents in a proceeding brought under this chapter. 182 or more days have certainly elapsed since the issuance of the initial disposition order. As we reviewed earlier, that was August and September of 2022. And the court is asked to determine whether or not there is clear and convincing evidence that the conditions that led to the adjudication continue to exist, and that there is no reasonable likelihood that the conditions will be rectified within a reasonable time, considering the child's, or children's in this case, age. And each child has to be considered individually, and of course I'll get to that. But the issues that brought these children into care, as this court originally framed, was that physical abuse. Throughout the duration of the case, Ms. Roscoe has, again, tracing back to this self-disclosure and some of the issues that were identified in Dr. Haugen's report, really been unable or unwilling to understand the extent of the conditions and how harmful those were to the children while they were in her care. That abuse issue was at the forefront of this court's focus at the time of removal. And it does not appear to me that either parent at this point is engaged in any kind of therapeutic interventions specifically designed to look at that issue. Not to mention, we have been unable to see whether or not any of the services that they have undertaken has had any demonstrable benefit. And that is as a result of the children's continuing disclosures increasing in severity as to the conditions that they were subject to prior to their removal. I had, of course, 2 letters again today, as we have in each review period, documenting that the children are making progress, but that exposure to either parent, specifically Ms. Roscoe, would certainly trigger regression for all of them and would be very harmful to their mental health. So in those particular areas, certainly we did not have any substantial progress, which was the biggest risk of harm to the children, which also presents clear and convincing evidence under subsection J. Seen any indication that Mr. Orner has any concern in alleviating those conditions. So certainly there is no reasonable time during which we can expect him to do that. And as it relates to Ms. Orozco, I can only look at the time frame that we've had her under our jurisdiction. Her indications that the conditions in the home were good times and bad times, as we heard today, which is certainly far and away an appropriate description of the conditions that led to the removal. I would note, as recently as in this last report period, as I was reviewing these exhibits, that one of the children talked about the fact that Richard was going to, quote, let the neighbor guy come and rape them if she didn't get her chores done. The oldest children all indicate that they do not want any contact and prefer adoption, and the youngest child certainly does not have any interest in continuing the conditions that she was subject to, and would be at risk of harm if she were to be in contact with the parent or parents that were the authors of the trauma that she has gone through, that require her as well as her sisters to continue to do therapeutic interventions, including equine assisted therapy, at least twice a week. But we'll get to more of that during the best interest factors. Right now, I'm looking at whether or not there's been progress under the case services plan. So the biggest point was the abuse, those branching issues, including perhaps substances and mental health, came to light, and I'm glad to see that there is some progress being made on those, but it's certainly not to the level that I would be able to return the children. They have been removed for over 16 months, almost 17 months at this point. It deserves stability and permanency and the opportunity to continue that in their home. And I cannot find that even 3 months is an appropriate amount of time to extend to this parent. There is frankly no way that we'd be able to see progress necessary to show benefit in 3, 6, or 9 months even at this point, given the reticence that we've seen from Ms. Orozco to engage in therapy up to this point, to engage in even conversation about personal responsibility as it relates to what happened to her children. And I do not see that that is a reasonable time to wait, given where the children are and what they need moving forward. We can't ask them to wait any longer. And frankly, that's what I'm worried about, is the children. These proceedings are about the best interest of the children, not whether or not, frankly, Ms. Orozco has just a little bit of credit is not enough. So a little progress being made is great, but it's pales in comparison to the progress that the children have made since they've been in care and their need for permanency and stability. So there is no reasonable time within which either parent could be expected to alleviate the risk of harm associated with returning the children to their care, including abuse, mental health issues, alcoholism, substances abuse. We're still looking for them to show employment, housing, transportation. None of those areas have been remedied to the extent that children could be returned to either parent. And as a result of that condition being present for the last nearly 17 months, I cannot find that there would be a reasonable time that any of those issues could be remedied either. Certainly there is a risk of harm under subsection J as it relates to both parents for all of the reasons that I've already articulated. So termination of parental rights for Mr. Orner is pursuant to MCL 712A.19B3, AII, CI, and J, and for Ms. Orozco, 3, CI, and J, for all the reasons that the court has articulated. As it relates to the best interest factors, now I get to talk about how well the children have done since they have been taken into the care of their maternal grandparents. There's an ongoing conversation, I think, in the background of many of our cases that we have about intergenerational trauma and how that can impact families. And I just want to commend these grandparents for stepping into that gap and making sure that their grandchildren have all the services that they need in order to try to stop that process, stop that cycle. Again, Ms. Stover did a great job of highlighting that through the court report that was prepared and submitted for today. The oldest child has been diagnosed with PTSD, ADHD, and cannabis abuse, uncomplicated, unfortunately. But he is in individual counseling, team group sessions. He's got a success coach, I think is what that was referred to as. He's discontinued psychotropic medications. And he's actively working and voicing his own needs. And he's come leaps and bounds since he's been placed with his maternal relatives. And that is unfortunately as a result of the disconnect from his parental home and from contact with his mother. And that was supported by all of his caregivers, including at this last juncture by Mr. Schoonmaker, I'm sorry. He also articulated on behalf of his child client that this child was considering coming and voicing for himself today, his preference. I'll just quote from the letter. If he's required to speak, express he wants the judge to understand that he has arrived at a clear and confident decision that adoption is the best option for his future success. So it's great that he's able to speak his truth, as Mr. Schoonmaker put it. He did that also to our LGAL, Ms. Heiss, and to our caseworker. And so clearly his preference is something I consider, but also the comparison home. And despite that relative placement, in fact, credit to them for the relative placement and the services that they have been able to offer for him. Despite that relative placement, there's no, does not serve his interest or the rest of his siblings to extend the case based on the relative placement. The benefits have not been utilized or available, even given the level of trauma that these children had and their process in overcoming even the barriers in sharing it. And some of the other reasons, of course, that Ms. Thomas argued for us. But despite the relative placement, it is certainly in his best interest, as well as the best interest of his siblings, that termination of parental rights for both parents be the order of this court. But I want to take a moment to talk about the other children as well. The second child is in 8th grade. The oldest child was in, I think, 10th grade, I read. Yes, so he's doing well, and the 8th grader is also doing well. She's one of the sisters that's participating in counseling and equine therapy sessions with her sisters twice a week with Ms. Moore, who continues to advocate that contact with her parents, especially Ms. Veresco, would be harmful to her mental health, which supports, in this court's opinion, as an expert, the termination of parental rights, as Mr. Schoonmaker's opinion would support it for the oldest child. She's a parentified child. This one as was identified during the trauma assessment, which that experience, as well as the complex trauma and abuse that she was subject to in the home, led to, unfortunately, clinically significant scoring in the areas of working memory, emotional regulation, shifting between emotional states, and self-monitoring. As a result of that, she is in that therapy, and she is, but she's doing well in those, and she is enjoying volleyball, which is done at this point, and some of the other activities that she has been diligently attending, thanks again to her relative placement. So her progress is credit to the relative placement. Her need for stability and permanency to continue that is established both by evidence of her progress as well as supported by her therapist. The 6th grader is in much the same boat, if you will. She unfortunately had an additional diagnosis as a result of the complex trauma and abuse that she suffered in the home with her parents. She has been diagnosed with ADHD, although this is consistent also with potentially being a result of that serious exposure to domestic violence, physical abuse, emotional abuse, parental substance use, and other forms of maltreatment, which have impacted multiple areas of her development, including attachment, emotional regulation, behavioral control, cognition, and self-esteem, which can mimic the diagnosis of ADHD, as I have been told before. So I hope for her that as she makes her way through, continues to make her way successfully through therapeutic interventions, that she can continue to enjoy progress in that area and perhaps overcome that diagnosis. as well as her diagnosis of PTSD, which she shares with all of her siblings. She's doing well in the relative placement. She also supports adoption. Her therapist supports adoption. So does our LGAL, our caseworker, as do both of those experts for all the other children. The last child is our kindergartner. She goes to equine therapy and counseling with Ms. Brene Moore on a weekly basis with her sisters. I don't know if she's with the horses, but she's definitely with Ms. Moore. She's in kindergarten. And she's been removed from this household for nearly 17 months at this point. Her trauma assessment indicates she was diagnosed with post-traumatic stress disorder, neurobehavioral disorder, and clinically significant scores in the areas of anger, post-traumatic stress arousal, and dissociation. All of these things happened as a result of the time that she spent in her parents' home for the briefest amount of time out of all the children, just basically based on her age. It's another chilling reminder that this kind of activity, torture, as it was described by more than one counselor today, advocate, has a significant impact on child development and creates significant challenges for these children. Her counselor is also Ms. Moore, who supports sustained disconnection from her mother as a result of those diagnoses and her need to have a stable and permanent home, free from any, even frankly, reminders of that time frame, so that she can develop the tools that she needs to be successful and to reach her milestones. She's doing that as a result of the placement in the relative home. Again, just to note, her treatment providers, LGAL, caseworker, present in favor of parental rights termination. There's a high likelihood for all four of these children of being adopted. The relative placement has expressed that they want to do that. They will be together, which is also a point of resiliency for them, and it will allow them to move forward in the home that has provided that platform for their success since removal. So as a result of all of those indicators, and despite the relative placement, there is a preponderance of the evidence here that termination of parental rights for both children is in the best interest of each child. Of course, we'll continue to review the matter as progress towards adoption is made. The children will be committed to the Department of Health and Human Services for that purpose. The goal of adoption is confirmed today and will be the goal moving forward. Ms. Orozco and Mr. Warner, you're both entitled to appellate review. I'll have a copy of the termination order for you today if you wish to appeal that. If you're unable to afford an attorney for that purpose, the court will be happy to appoint one to assist you with that, as well as the transcript as necessary. That request must be made within 21 days, as well as that any motion for reconsideration, rehearing. You have the right to keep your identifying information current with the Central Adoption Registry. Denial of release or identifying information. Deputy Ames is handing you a copy of that today, Ms. Orozco, to tell you how to do that, and then the initial copy of your advice of rights form. So the record should reflect she has received that. I will prepare the order noting the findings from the review, as well as the termination of parental rights. And we'll have our next post-termination review under the adoption code, which will be confidential on February 7th, 2024 at 1:00 p.m. Unless there's any questions, that's all.
What started as a routine court hearing turned into a shocking courtroom moment when one defendant failed to appear. Without hesitation, the judge issued an immediate bench warrant and set a $10,000 bond, proving that missing court is never a small mistake. In this video, you'll see how a single absence instantly changed the defendant's future, and why judges take failure to appear so seriously. Watch until the end to see the moment everything changed. Like, comment, and subscribe the Legal Lens for more crazy courtroom drama, and be sure to subscribe to the Legal Lens and turn on notifications so you never miss another fascinating courtroom story. Thanks for watching, and we'll see you in the next case.